Good afternoon.
Can you hear me?
I can. Can you hear me, Jatoy?
Yes, ma'am. I had the mute button on. I didn't know.
Okay. All right. They've told me that the best way to do these meetings is to turn off everybody's video and everybody's audio. And to just use the chat pod, because what's happening is the meetings are getting huge. The files are becoming so big that they won't upload, and even YouTube doesn't want them.
Okay.
So
Wow.
I'm going to have you turn off your camera now that I've said hello and you've seen me. Can you turn your camera off?
I can't see you.
Well, you see a picture of me. I guess now that you've heard me, I should say.
I don't see anything. Okay, I'll stop the video though
Okay,
and
all
put
right.
my
If you'll
phone back
stop the
on
video,
mute.
and then what we'll do is they said the best way to do this is to have everyone use the chat pod.
Okay.
So if you have a question, go ahead and type it in, and then we can keep the files smaller
Okay.
so that it doesn't get crazy. That's what they have told me is the right way to do this. So live and learn. All right. So I'm gonna go ahead and
Wanna-
do a share screen. So if you want to turn off your microphone and your camera, I will do a share screen here. Yes. And I'm going to share my desktop. Let me get back to the right desktop. There we go. Okay, so at this point in time, you should be seeing the splash page for our classroom. And what I will do is, if you have any questions, you can go ahead and, chat, ask a question, chat in the pod. If you go over to the more section, you should see where there is a place to type in any questions or information. So what I'm going to do is go over the tasks for week number 2, and then I'm having to convert these to YouTube files and then putting them up on YouTube. And so you might have seen where I shared the link to the week number 4 meeting that I recorded yesterday, and put a note in there that you certainly don't need to listen to that now because we're only in week number 2, but it is there for you to go back and listen to for week 2. And basically, it will launch a YouTube file. So I'm going to do the same thing with this chat, and then also the week 3 chat that we're going to do as soon as we're done with this one. And you'll see that what I'm doing is sharing information about the tasks. Just quickly, they said, 15 or 20 minutes is all we need to do. It's just a way to make sure that you hear it come out of my mouth, some of the things that you might want to be working on and thinking about when you are doing your tasks. So if you have any questions along the way, Jatoy, go ahead and type them in, and they should pop up on my screen for me to see. Let's see. Okay. All right. Excellent. Okay, so it did come up just fine. All right, so let's take a look. Week number 2 is where we are now. Time flies when you're having fun. And you have a discussion, a quiz, and a written paper, just like in week 1. So let's start by taking a look at the discussion question for Wednesday. A friend of yours wants to hire a lawyer, but he or she doesn't really understand the different ways that lawyers enter into fee agreements with their clients. What are some of the different fee agreements that lawyers enter into, and do these apply to every area of law? Why or why not? So this is your discussion board. Your main post should be at least 250 words or more, and then of course you need to reply to at least 2 of your classmates' postings. Fees are a very important part of what attorneys and paralegals do, because guess what? We all want to get paid. The last time I checked, I don't get to call my mortgage company, and you don't get to tell your children, well, you're just not going to eat this week because the nice people that came to mommy or daddy's office decided not to pay. People need to pay for our services, and therefore, we need to make sure that people understand up front what it is that they're going to be paying for, how they're going to pay us, and why. You hear people talk about retainer fees a lot. I'm going to pay a retainer to my attorney. A retainer is an amount of money that is paid up front and hasn't been earned yet. So when attorneys ask for retainers, it's to start the litigation process or to start the work that the person needs to have done. And attorneys need to put that into a trust account, a trust bank account, and keep that separate from their operating account, because the only money that the attorney is entitled to is the money that they've actually earned. So if you have a client that comes in and pays you a $3,000 retainer to get going on some litigation, and during this month, you and the attorney only spend, let's say, 5 hours, and it comes to $1,000 worth of billing, the attorney is not entitled to that whole $3,000. The attorney is only entitled to actually spend the $1,000 that they have earned. So they would put the $3,000 into their trust account, and then at the end of the month, when they do the billing, they would transfer $1,000 that has been earned from the trust account into the operating account, leaving a balance of $2,000 in the trust account for that client so that we can pull on it again next month. So those are retainers. You also hear people talk about contingency fees. Now, contingency fees go something like this. I'll take your case, and if we win with a settlement, I will charge you 33% of whatever the winnings are. If we go all the way to trial, my fee is 40% of whatever we recover. That is typical of a lot of attorneys. If they're taking the fee on a contingency basis, they're basically saying, I'm betting on the fact that I'm going to be able to get a settlement or some sort of winnings, I guess is a nice way to put it, recovery for my client. So they don't take any money up front as a retainer would be. They basically say at the end of the litigation, if we settle, I get 33% of whatever you settle for. If we have to take it to trial, I get 40% of whatever we win at trial. If they lose, the attorneys don't get paid. They would only get paid for their expenses, things like postage, traveling, depositions, things that they actually had to pay out of their own pocket. So contingency fees are a little bit of a crapshoot, and you have to be careful with them. There are certain kinds of cases that you can't take contingency fees on, and you will read about it this week. One of them is you can't take contingency fees on family law cases because you can't be betting on whether or not somebody will get the custody of their children or not have to pay alimony or pay less child support. The courts say you can't take contingency fees on family cases. You also can't take contingency fees on criminal cases because that's kind of like hedging a bet on, whether or not you're going to win. Now, the thing is, what's at stake? A person's freedom. And so what would an attorney potentially be tempted to do in order to keep the person's freedom and get paid? You can't guarantee someone or incentivize them by saying, hey, I'll take less of a fee if we settle and you don't go to jail. Well, that's not going to help. If the person is in jail, how are they going to pay you anyways? It's not about winnings at that point in time. You've got a person who, if they lose in a criminal trial, they're going to prison. So those are some of the different kinds of fees. Another thing that attorneys are doing more and more nowadays is something called limited scope representation. Limited scope representation is no, well, for criminal cases, absolutely, you probably would want to take retainers up front. Criminal cases can be very expensive to litigate and to try. And yes, pretty much anything that you don't have a contingency fee for, you're going to see attorneys wanting retainers. Sometimes you figure out how serious your client is by whether or not they're willing to pay a retainer. Some people say, oh, well, I can't wait to sue my neighbor for this and this and this. And then you tell them, I need a $2,000 retainer to get this started. And they fall back to a different position and go, well, I want to go home and think about this. So you find out if it's going to be worth, sinking a lot of time into something, if somebody is willing to and able to put up a retainer fee to start the process. All right, limited scope representation is where the attorney does some of the work and the client does other parts of work. And I'll give you an example. I've got one right now where the woman used to be an attorney and she got into some trouble and she lost her license to practice law, but obviously she didn't forget how to practice law. And she has a case that she wants limited scope representation. She wants someone representing her. She wants somebody who will go to court and speak to the judge and the jury and other witnesses on her behalf. But she is able to write her own pleadings and just let us take a look at them. So that's called limited scope representation. She's pretty much purchasing the ability for someone to come in and to represent her in court is basically what she's doing. Hello, I saw somebody else come on in. And just wanted to let you know that we are disabling audio and video for everyone to try to keep the size of the files down. But if you want to chat, go ahead and tell me. I saw just a very quick glimpse. It's Rashanika. Okay, great. Nice to see you. Glad to see you here. Okay, so in limited scope situations, you're really only asking your client to pay what it is that they can't or aren't willing to do for themselves. So that's just a little bit about some of the different kinds of fees that are out there and the arrangements that can be made. And you're going to learn more, obviously, by reading this week and participating in the discussion board. Okay, so the other item that you have to work on this week, other than your quiz, is this week 2 assignment. And the week 2 assignment is a paper, which you should be familiar with because you've been asked to write one for week number 1. And for week number 2, this is a 500-word paper that asks you to explore the following item. A friend of yours says she's a paralegal working for herself. You learn that she helps people draft wills, and she answers real estate questions, and even some employment and small criminal cases. You recently learned that paralegals need to be careful about the unauthorized practice of law, and you're worried about your friend and her business. What should you do? What do you advise your friend is wrong with what she's doing in her business? What can your friend do without being considered to have violated the rule regarding the unauthorized practice of law? This is a big deal. Attorneys go to school for 4 years at the undergraduate level and then go to another 3 years of law school and then take these ugly big tests called bar exams in order to get licensed to practice law. Only people who have graduated from an accredited law school and have passed a bar exam have the legal right to be giving legal advice and practicing law. Just because you went to law school doesn't give you the right to practice law. You have to be licensed in a state. And that involves taking a bar exam, or if there's reciprocity between several states, you might be able to just go through a background check and pay a fee to get a license in a second state or a third state. But attorneys are really careful about making sure that their paralegals are not practicing law. Paralegals have the ability to assist. Paralegals have the ability to do research, and to be quite honest with you, it can be a very easy line to cross because as a paralegal, you might have more practical knowledge about a case than the attorney does. Lots of times it is the paralegal who's doing the research. It's the paralegal who's fielding the phone calls from the opposing counsel or the client. And so you may feel that you have a more intimate relationship with that case than the managing attorney does. But still, that doesn't give you the ability to practice law. What does practicing law mean? Well, it means that you are giving legal advice. So if people are wanting to draft wills, and your friend has some simple questions that they can answer, or they come to her and say, this is what I want, will you write it up in a pretty format so that it looks good? That's one thing. Real estate questions. Do I need to do this or that? Well, guess what? Probably they're going to be better off to be talking to a real estate professional or a tax professional. Many times real estate questions have to do with tax consequences, and even attorneys will beg off of those questions and will say to someone, hey, you really ought to be talking to your tax advisor because I am an attorney, but I don't give tax advice. When it comes to employment issues, stating what the law says, giving somebody a copy of the law, telling someone where they can go to the court to get some papers that they would like to file and start their own case, that's all fine. The same thing with criminal issues and the same thing with real estate issues. If the question is there a law about this, then a paralegal can certainly pull up the law and hand it to someone. Where you would get into trouble is if you start interpreting it. Anybody can go look up the statutes and print them out and interpret it themselves. But in order to give someone a legal interpretation of a law or of a case or of a situation, that's where we have to have people who have gone to law school and passed bar exams. What can your friend do? She can print off information. She can prepare forms for people. She can tell people where to go down to the courthouse to do their filings. She can look up how much it costs to file different cases and tell people that. Where she has to be really careful is not crossing the line to give legal advice. Okay? So again, this is a topic that you're going to read much more about this week. And after you've done your reading, you should write an APA formatted paper that is at least 500 words, and make sure that you are citing your sources of research down at the bottom of your paper on a separate page. Citing information is always important. You're better to oversight than undercite. You'll never get in trouble for citing too much. You can get in trouble for not citing. My rule of thumb is if it's information that the average person walking down the street would not know, then you need to cite it. You don't have to cite things like the sun comes up in the east And when it rains, you can get wet when you walk outside. That's the type of information that people walking up and down the street readily are aware of. But when it starts coming to legal information or information that you're just learning, it's very important that you cite where your sources are so that whoever is reading it knows where to find that information. Okay? All right. So that is a quick overview of what is happening in week number 2. You, of course, if you're not here live and you're listening to this archive chat, then you need to go ahead and do a synopsis of it in the area. Let me go back here to the area. Let me show you for those of you who are going to listen to the archives. When you click on the assignment that says week 2 live session, if you did not come live, then these are your instructions in order to post an assignment. Okay? All right. So let's see. We still have Jatoy and Rashnika. Do you have any questions that I can answer for you before I let you go for today? And what I'm going to do is I'm going to end this meeting, and then I will let the audio archive. And if you give me just a couple of minutes, then I will start the next meeting. You can go in there and wait for me if you would like. And that is going to be a pre-recorded session for week number 3. But if the two of you come on into that as well, I will give you the credit for having attended without having to do the synopsis. Okay? All right. Any questions before I let you go?
I think I'm fine. Can you hear me?
Yes.
Okay. I didn't know if you could hear me. This is Rashanika.
Yep.
I think I'm fine.
You
I
said,
have,
yep.
I was surprised when you said about like citing for the paper here, and I
Yeah.
was wondering when I did my last paper because I most definitely did not cite anything, but I know it was more of a
That was more of an
opinionated
opinion.
essay.
So that's really okay. That's not the biggest deal. Not a problem.
Okay. Okay, that
Not
was
a
my only question,
Yeah,
the
not a
citing and
problem.
stuff.
And Jatoy, to answer
Oh,
your question, limited scope is basically asking the client to pay only for the things that they cannot do for themselves. Yes. And like I said, think about when you become a paralegal, if you were to have a legal issue and you were to go to an attorney, you probably could write up your pleadings and those types of things on your own and save money. And you might only need to pay the attorney to actually go and represent you in court.
Oh, can you hear me?
Yes, I can.
Oh, okay.
Yep, yep.
Okay.
Okay.
I didn't even know I missed one of the assignment on Sunday. I didn't even know I missed that. So I got 2 to do now. Okay.
You do. Absolutely. Get working on that.
Okay. Well,
Okay.
I'm
All
pretty
right.
much.
I am going to close this one out. And again, for the most part, we're going to try to limit, we're going to not use video, and we're going to try to limit the audio because I'm trying to make these not huge files. I'm having to turn them into YouTube documents because the documents are too big to send as an attachment to the news forum. So what I'm going to do now is I'm going to stop sharing, and I am going to get out of this meeting. Like I said, I'm going to let this one archive, and then I will come on in to the next meeting in just give me about 5 minutes. I'll go into the next meeting, and then we'll do week number 3's pre-recording. And if you are with me, you can get credit for that one as well. Okay, so give me about 5 minutes, and we'll start the next meeting.
okay. Yes, ma'am.